Welcome everybody. USCIS delay hits 821 days on a green card case. Immigrant files Mandamus lawsuits after 27 months of inaction. Can the courts force USCIS to finally decide? Today is Monday, June 16th, 2025, and let's take a look at this case. So, the summary of this case is that after waiting after waiting over 821 days for USCIS to process the immigration petitions, including the I-130 for a spouse, I-765 for work authorization, and I-131 for travel, this couple filed a federal mandamus lawsuit. So this was filed in the U.S. District Court in the Northern District of Texas. And here are the plaintiffs, and then and here are the defendants. So these defendants are sued in the official capacity as agents of these federal agencies. And then this is the complaint for writ of mandamus and the violation of the Administrative Procedure Act. All right, so here is the introduction. So there are two plaintiffs, and the complaint alleges that on January 20th, 2023, the plaintiff lawfully filed a Form I-130 petition for alien relative and with the USCIS for her spouse to become a permanent resident of the U.S. And in addition, the plaintiff filed Form I-485. The other plaintiff filed I-485 application to register for adjustment of status and then paid the associated fees. And along with the I-485, the other plaintiff filed I-765, which is the application for employment authorization, and Form I-131, which is the application for travel document, which is the parole document, to request advance parole for travel authorization while his Form I-485 remains pending with the USCIS. This action is brought as a result of their failure to adjudicate plaintiff's I-130, petition for alien relatives, and the plaintiff Form I-765 application for employment authorization, and Form I-131 for the application for travel document. And they're saying that it's been pending for over 2 years and 3 months. Okay, and then they're saying the delays is making a decision on plaintiff's respective forms extends well beyond the Congress guideline for 180 days for immigrant benefits under 8 U.S.C. 1571, and then there also is in violation of the Administrative Procedure Act. So there's two parties, like I mentioned. The plaintiff is a lawful permanent resident, and she filed a Form I-130 petition for alien relative. And then the other is not a U.S. citizen, and but they're residing in Texas, beneficiary of the pending I-130, and also pending. Like I said, they filed one of the applicants filed the I-485, the adjustment of status, Form I-765 and 131. Like I mentioned, they are suing a couple of defendants as in their official capacity as part of working for, or the secretary, or working for the agency director. And then the exhaustion of administrative remedies. The plaintiffs have repeatedly requested defendants to make final decisions on their respective forms, and they have made numerous inquiries with the USCIS without any resolution. In terms of the factual allegations, they paid the fees, they filed these forms, and they have completed the biometrics. And they go on to say the same thing, that they're waiting there. It's beyond what is shown in the historical averages. Again, the historical averages are a little bit higher than when this case was filed. So they are on the count one. They're talking about the violation of the APA, the Administrative Procedures Act, the Form I-130, and then there are no other adequate remedy available to plaintiffs. They also do a count two for the violation of the APA Form I-131, which is the application for travel document. And then they talk about the violation of the APA Form I-765, which And also, they talked about what they're requesting from the court is to compel defendants and those acting under them to perform their duty to adjudicate plaintiffs' respective forms. And again, you don't know which way they would adjudicate, but they are asking them to adjudicate it. Anyway, if you like this, subscribe, give me a thumbs up, so I can bring you more of these types of court cases. Thank you so much. Bye bye.